Mr. Jebb was an Australian soldier in the Second World War. He suffered from a number of medical conditions arising from his service, including anxiety, a hearing disorder, and some ongoing effects from a gunshot wound to his shoulder. He was in regular employment from the late 1940s until 1980, when he was forced to retire due to his medical conditions. He applied for and received a war pension, but then he applied for the higher levels of that pension, which were available if the former soldier was incapable of working 20 hours a week, and then an even higher pension if the soldier was unable to work even 8 hours a week. The assessor appointed by the government found that he was able to work 20 hours a week, and so he was denied the additional pensions. He then started the review process, and by the time his application got to the Repatriation Commission, even the Commission accepted that he was no longer capable of working even 8 hours a week. However, the Commission felt that because it was a review body reviewing the initial decision of the department, it should only consider the information which had been before the department at the time of that initial decision. On that basis, they affirmed the original decision. Mr. Jebb's lawyers strongly disagreed with this approach, arguing that the Commission should consider Mr. Jebb's circumstances as at the date of the review. Can you see the importance? At the date of the original decision, Mr. Jebb wasn't eligible for the higher pension, but by the date of the review, he clearly was. The matter then came before Justice Davies in the Federal Court. Now, a lot of the decision focuses on the specific legislation, but Justice Davies said those provisions allow the Commission to make a determination which is appropriate, having regard to the facts as found at the date of the lodging of the application, as they stand at the date of the determination, and having regard to any material changes which may have occurred between those dates. This decision is now regarded, though, as being wider than the initial legislation. It stands as authority that, depending on the specific enactment, it is definitely permissible for a review tribunal to make an entirely new decision based on all the facts as at the date of the review.